Good morning to all of you. Welcome to Legal Matters by Sai Babu Sankara. The point for discussion in this case is whether a probationer can be terminated without giving notice during his period of probation. Yes, definitely yes. If the services are not satisfactory to the employer, during the probation period, the employer can terminate him even without giving notice. This is what is stated by the Supreme Court of India, Honorable Justices J.K. Maheshwari and K.V. Vishwanathan, in the case of State of Punjab Vs Jaswant Singh, in Civil Appeal number 1187 by 2014, a few days back. So, please hear carefully. During the probation period, if the conduct of the concerned employee is not satisfactory, then he can be terminated without giving notice. That is what probation says. So, why a person is kept under probation for first 1 or 2 years? Normally, our probation period was at that time only 1 year. So within this 1 year, you must satisfy the department that you are able to discharge your duties or you are fit to conduct, fit in the department. If not, they can terminate your services even without giving any notice. But of course, the question is whether it is against the natural principles of natural justice or not. This is the question. This is envisaged in this particular case. So Mr. Jaswant Singh, he has been appointed as a constable and he joined the duty on 12/11/1991, so 1989, 12th November 1989, and he has to undergo the training. He was undergoing training in PTC, that is Police Training College, Hoshiarpur, from 12/11/1989. He was assigned the constable number PC 1669. While so, the recruit pieces, they were sent to Amritsar as security guards on some work, temporary work, 3 or 4 days, and they have to come back. But our friend, Mr. Jaswant Singh, he did not come back. He remained absent for 21 continuous days. He was not found. He was declared the deserter, and during the period of 6 months, last minute, he tried to come but was not allowed. This is the situation. Since the probation period, since the desertion notice was not served on him, the regular procedures were followed and he was dismissed from service as per Punjab Police rules, rule number 12-21. 12-21. What does it say? Rule 12-21 of the Punjab Police rules say that a probationer who is found to be unlikely to prove an efficient officer of the department, he may be discharged by the Superintendent of Police at any time within 3 years of enrollment, and no appeal lies on this order. And this is specifically stated in Punjab Police because it's a discipline department. You have to maintain discipline, is it not? Alright. Anyway, now this man, having been terminated on 28/3/1991, his services were totally discharged. He was dismissed from service literally on 28/3/1991. Now what to do? He has filed a civil suit. He has instituted a civil suit in OS number 306 by 94, 306 by 94 before the JCJ Amritsar. Okay. The JCJ Amritsar was of the opinion that the principles of natural justice were not followed. Therefore, they have given a decree, a partly decree, stating that his service, his perks or the salary should be given. Against this, they approach the trial court, they approach the high court, and all of them with one eye said the principles of natural justice were not followed. Now the matter has come to the Supreme Court. Supreme Court has clearly stated that. So basing the case of, there are two important cases. Sher Singh XPC. Sher Singh is also a former constable versus State of Haryana, 1994. Another famous case is Sukhvinder Singh. Sukhvinder Singh versus State of Punjab. So in these two cases, it was held that if any employee was found unsuitable during the probationary period, employer has got right to terminate his service. So the distinction between simpliciter termination and punitive termination is explained by Honorable Supreme Court of India. So if a person is under probation, if he is not able to meet the goals, if he is not proper in his duty, definitely simpliciter termination, finish. But for punitive termination, lot of inquiry has to be done, he has to be given opportunity. Right? This for the simpliciter termination, the so-called principles of natural justice do not apply. So normally I was also under the impression that Supreme Court also will agree, but here they have negated the orders of the lower two courts and also the High Court also. So sometimes such incidents happen. So please refer to the case, particularly the service matters. So probation period, that's why probation period is an important aspect. We were told to be very, very thorough in every topic during the probation period. Of course, we were successful in completing the probation. Present days, they are different in the police department also, whatever it is. So here, please remember the defense of the constable also. He stated that while returning from the duty at Amritsar, he fell sick, he was hospitalized. There is no time for him to intimate to the concerned authorities. Ultimately, when he wanted to join, they did not admit him. Therefore, his right to admission, right to employment was waived off. First appeal allowed, and that means the government has to take him. Second appeal allowed, the government has to pay salaries to him. Ultimately, the matter came to the Supreme Court, which has cleared the air in this matter. Please read the judgment and enrich your legal knowledge. Thank you.